My name is Tom Shaw. Today, I'll be presenting on the topic New SECURE Act Changes for CPAs, Maximize IRA Planning. My background is that I'm an attorney with the Forster Bowman Law Firm in Maitland, Florida. I've practiced state and trust planning for 36 years, and I'm board certified by the Florida Bar in the area of wills, trusts, and estates law. This is the agenda for today. Maybe we'll spend most of our time on the 2019 SECURE Act and on different kinds of IRA planning that you can do to address the SECURE Act. I will very briefly cover the 2020 CARES Act, just because there are some parts that may affect your clients going forward in future years. Just give you a sort of an overview. Before the pandemic, basically Christmas Eve 2019, Congress passed the SECURE Act. It made major changes to the IRA distribution rules, and that's what we'll talk about today. Then post-pandemic, there were some temporary loosening of the IRA and 401k rules designed to provide some economic relief for people who might be affected by the shutdowns. And then finally, early this year, the IRS proposed some regulations that cleared up some open questions, added a few surprises, which we'll go over today, and are effective generally for January 1, 2022, but there is a transition rule. We'll also discuss that as well. So let's start with the SECURE Act. It basically changed the rules for IRA distributions for owners as well as for named beneficiaries. So it affects both people who own IRAs now and for people in the future who may be named as a beneficiary on their IRA. But there are some ways to get a stretch out still, even though the statute basically imposed a new 10-year limit on the stretch out. We'll talk a little bit more about what that stretch out is. So traditionally, the way we plan for IRAs is that we obviously the account owner wanted the benefit of the IRA during his or her lifetime and get those distributions to pay for retirement expenses. But the goal and the planning after that is if the IRA was large enough that it would still be around at the death of the account owner, then to pass that benefit on to typically children or other beneficiaries. And we did that planning with what was called a stretch out, where we basically were setting it up so that the distributions after the death of the account owner would continue on for either the joint life expectancy of the two or for the life expectancy of the beneficiary. And basically, we were stretching out when distributions had to be made over the lifetime of the beneficiary. And that basically deferred income tax, because with IRAs, every dollar that comes out is taxed as income to the person receiving it. So by doing the stretch out, we were deferring income tax over the life expectancy of children, which might be 20 or 30 years. I'll just give you an example of what the benefit of that stretch out was. Assume, for example, an IRA has $1 million in it, that it's got assets that are growing at 6% per year. The beneficiary named is the child of the account owner, 50 years old. The beneficiary is in the 37% tax bracket, so they're already in the top tax bracket. And the beneficiary, as it receives income from this IRA, is invested at 5% after-tax return. So those are the assumptions, just to see what's the benefit of stretching out this IRA distributions over the life expectancy of this 50-year-old beneficiary. So without the stretch out, in other words, being forced to distribute it in 10 years, the difference is almost $500,000 of total assets remaining after 10 years after the death of the original owner. And if we stretch this out even further over 20 years, the difference is almost $600,000. So the loss of the stretch out is a big deal. And that's really the biggest change that came as a result of the SECURE Act in 2019. Now, there are some exceptions, and it's important to look at those exceptions, because if you can get into the exception, then you don't have the 10-year rule. You still have the life expectancy rule, and you still have the stretch out. So I guess we'll start by saying the 2019 SECURE Act took away the stretch out, but there are some provisions under the SECURE Act which give us the stretch out back. And here's a list of them: transfer to a spouse, transfer to someone who's within 10 years of the owner's age. This is the boyfriend-girlfriend rule. A transfer to a minor child of the account owner, a transfer to a disabled person, or a transfer to a chronically ill person. But note, if any of these are payable to a trust, And we'll talk more about trusts as we go through today. If trust is a beneficiary and there's a mix of beneficiaries who qualify for these exceptions and beneficiaries who don't, then the 10-year rule is going to apply to all the beneficiaries. So part of planning now under the SECURE Act is to figure out how to make sure that the IRA only has either qualified or non-qualified beneficiaries, but not a mix of the two, because if you do that, you just end up back in the 10-year rule. And as we'll go through today, there's a lot of the proposed regulations filled in a lot of the blanks, and so that's going to be very helpful. So let's go through the exceptions one at a time, just so we can kind of see how we fit into those. First exception is a transfer to a spouse, and all the typical planning that you've thought of in the past continues to apply. So spouse can treat the IRA as an inherited IRA and take distributions based on the payout that was already in place or on the life expectancy of the surviving spouse. But more typically, we propose that the spouse roll over the IRA and treat it as the surviving spouse's own IRA. And that means now that the surviving spouse is the owner of the account, and we start over with all the rules for who gets to be named as beneficiary, when the distributions can be made, and those sorts of things. The proposed regulations also helped us because there was this issue about someone who had been, where the account owner had died, they were not taking their RMDs, and could the surviving spouse delay those distributions until age 72? Because as we'll learn later, the required minimum distribution age was raised, and there was concern that the surviving spouse would have to take it at 70 and a half. The proposed regs now say, no, that surviving spouse, again, can use the age 72 under the new act. So there are some, the proposed regulations have really helped us in this regard. The other exception, the second exception, is a transfer to someone within 10 years of the owner's death. Now, as I said before, this is the boyfriend-girlfriend exception. Basically, the idea being, look, if someone is a significant other in someone's life, they're typically about the same age. And we really weren't trying to get at people who are taking distributions out sort of on the normal course. Part of what the SECURE Act was doing, the reason it got passed, Christmas Eve of 2019, is it was going to raise a set amount of money, and it was really just part of the pay-go rules for Congress. They needed a set amount of income. If they had changed the stretch out to 10 years, it raised a certain amount of income, and part of that was because, as a policy matter, it made sense for the owner and the owner's spouse or significant other to be able to to have the benefit of the IRA, but it was never intended, or at least that was a discussion, to benefit the children, who this was not really their retirement planning. This was just a sort of a windfall. So that's how the tax happened. But note that it doesn't have to be a significant other or boyfriend, girlfriend. It can be anybody who's within 10 years of the age of the account owner. So again, if account owner wants to benefit a sibling or another relative, situations where the uncle and the nephews are the same age because of when the different children and the different family lines were born, or it can even be a friend. If they're within 10 years, they'll get the stretch out rule. And so someone would be able to benefit a friend or a relative who's within 10 years of their own age by naming them as a beneficiary, and then they would have the ability to stretch out those distributions over their entire lifetime. The other benefit of a stretch out I didn't mention earlier is because of the stretch out, you're not paying income tax as early. And when you're not paying income tax as early, you get the benefit of deferring that tax, and the tax not paid is now being invested and growing. The third exception is a transfer to a minor child of an account owner. And notice I put child in large caps along with the word minor. And the reason is because this exception is narrower than it looks. It's only for the account owner's children. So, you basically have to have parents who own the IRA who have children who are who are minors. This exception does not apply if you name your grandchildren who happen to be minors, if you name nieces and nephews or other people who are not minors. So that raises the real question is, well, what is a minor? State law traditionally nowadays, most states' law says age 18. There are a few states that say age 21. Obviously, there's some different rules for alcohol purchases and things like that. And then there's some federal law, especially the healthcare laws, that say you could be 26 and still be considered a minor. So that was an open question that most people assumed the answer would be 18. Well, the proposed regulations say, no, it's 21. It also happens to be the same age used in the federal gift tax regulations. So there is a reason for picking that. But the beauty of that is you get 3 extra years, which no one was really expecting. So this is a positive that came out of the temporary regulations. Now, this minor child exception is temporary. So when the minor child reaches age 21, then the 10-year rule kicks in. So basically what you're getting is however many years from the date of the account owner's death until the child reaches 21 plus 10 years. That's really what you're getting for minor children, unless there's another exception that applies. And then the proposed regulations, just as an aside, in case you have someone who fits this, points out that for defined benefit plans, which is a different type of, it's an ERISA plan, it's a retirement plan, it's not an IRA, those plans sometimes define minor to be age 18, again, because that's what most states did. If that's the case, those defined benefit plans can keep their younger age. Now that's important because if you have someone who's got an IRA and they've got getting a distribution from a defined benefit plan and it's now rolling into an IRA, you have to stop and look to see what age people were and because you now got a mismatch on the ages. So I just raise that just so you're aware there is a potential mismatch there. The next exception is a disabled person. And the big question everyone had is who's considered disabled? And I did some seminars on this, last year, and we just sort of made some guesses about different things. The problem is that there are different definitions in state and federal law. And so it was very difficult to guess what might be considered disabled. And then even within the federal government, different programs have a different definition of disabled. So the proposed regulations just came out and said, look, this is the definition, IRC section 72M7. Now that section is a tax code section that deals with employee annuities and plans, but it has in it a definition of disability. And so the IRS has just sort of tagged onto that and said, look, if you want to come into this exception to the SECURE Act and get a life stretch out for the beneficiary who's disabled, they need to meet this definition. Now, basically, it's being unable to engage in substantial gainful activity, basically earning wages, by reason of a medically determinable physical or mental impairment. And that impairment's expected to be long continued and indefinite, or it's a type of impairment that eventually results in death. So that's fine for people who are able to be gainfully employed, but particularly for minors, a lot of them don't have jobs, they can't get jobs. How do we define that person as disabled? Let's say you got a 4-year-old, well, they're not going to go get a job probably. So how do you define the disability there? There, they basically just said they have a severe medically determinable impairment. If you're under 18, you don't have to prove that you're unable to engage in substantial gainful activity. So they just modified it a little bit to sort of deal with that situation that's not covered by Section 72. And then to make things even simpler, is said, look, if the Social Security Administration has said you're disabled, and this is under 42 USC 1382C, and this is in regard to supplemental security income, is that if the Social Security Administration has said you're disabled, and you've gone through that whole process and been determined disabled, then you're disabled, and you don't have to figure out if you fit into these other rules. So it's good to know there is a safe harbor there for a disabled person. Now, sort of related to that, the last exception is a chronically ill person. And there, again, what the proposed regulations did is they said, look, we're going to go to Section 7702B. And this is a code section that is in regard to long-term care insurance. And they said, look, under long-term care insurance is designed to provide a benefit if you're chronically ill. So we'll tie into that code section. And if you meet that definition, then you're chronically ill for the exception to the stretch out rule, and you get the stretch out for this person. And basically, if you've ever dealt with long-term care, you'll recognize it immediately. Unable to perform, again, without any assistance or substantial assistance, at least 2 activities of daily living, and that you're unable to do that for a lengthy period of time. Now, that lengthy period of time, I probably should have highlighted because that's different than the code section 7702B. That section says for more than 90 days. The regulations for the SECURE Act say, no, we don't mean a short term. We don't mean something short term, chronically ill. We mean you're chronically ill for a lengthy period of time. They don't say what that is, but we're assuming definitely more than 90 days, since that's what the code section says. And then not able to do these two activities due to either a loss of functional capacity or some kind of disability that basically is a loss of functional capacity, or that you require supervision to protect yourself from your health and safety due to a cognitive impairment. So, for example, if someone is, has Alzheimer's disease, and you can't really just let them stay at home without somebody being there with them, or they'll wander off. That's what that third one's getting at. And just so you know, these activities of daily living are basically you're able to feed yourself, you're able to use the bathroom by yourself, you're able to transfer from, say, for a bed to a chair on your own, able to bathe yourself, you're able to dress yourself, and that you have continence. So if you can't do two of those things without a lot of help, then you're considered chronically ill for this exception. Now, the other thing sort of common to both of these last two exceptions is that you have to provide proof of your disability or chronic illness to the plan administrator or to the custodian, typically for IRAs, a custodian, by October 31st of the year following the date of the account owner's death. So someone dies, the beneficiary is a disabled person, the flag should go up. I need, by 10 months from the start of the next year, I need to make sure certain things are provided. I need to go get the proof of the disability, proof of the chronic illness, and get that to the custodian by October 31st of the following year. Unfortunately, they didn't define disabled person in the proposed regulations. So I think we just have to go back to the regulations, or hope that you already fit into the exception because the Social Security Administration has determined the person is disabled. For a chronically ill person, they basically have to get a medical provider, and there's a definition of that, but it's not just a doctor, but medical provider provide written certification that the person's disabled. And you might think to yourself, well, okay, so we get the certification, but what happens? Do I have to keep doing this every year? The answer is no. The way the exceptions to the SECURE Act work is the test date is the date of the account owner's death. So if on the date of the account owner's death, the named beneficiary is disabled or chronically ill, then you're done, you get the stretch out, and that's the end of the discussion. Now, where it can get a little weird, and I've got this note here at the end of this slide, where it can get a little weird is if, there are, is the way the timing works. So let's say, for example, there's a minor child who becomes disabled or chronically ill after the account owner's date of death. The exception doesn't apply. This exception for disabled or chronically ill does not apply when the minor turns 21. Now, if the minor child at the time of the account owner's death was also already disabled or already chronically ill, then when the minor, then that exception would apply, and it wouldn't matter when the minor child turned 21. You'd continue to get the stretch out. So that's just something to keep in mind, is that the test date is the date of death. It doesn't just continue on. And then with this minor child, because you get this sort of extension period, you have to sort of look at how that fits to make sure that you're not running afoul of that exception, or how those exceptions work. Now, there's some other changes that were made by the SECURE Act. Obviously, this is one that we focused on, because if you can get into the exceptions, then you get the stretch out, and we go back to the same old planning. But what if you can't get the stretch out? What if your people don't fit any of these exceptions, and now you've got 10 years and then they get the money? And this is really bad if the beneficiaries that are being named are the kind of people that will just take the money and waste it. And your goal was, I built up this huge IRA. It's helping me make sure that I'm comfortable during my retirement, but I want to make sure that it does the same thing for my children or for other beneficiaries. How do I make sure I get this stretch, or something equivalent to a stretch? So we'll talk about that in a little bit. But some of the other changes that were made by the SECURE Act, and I already said it, is they changed the date for required minimum distributions from 70.5 to 72. And again, for income tax planning, the way we work with IRAs is you want to start taking distributions as late as possible, and you want to take as little as possible, so that the fund will keep growing income tax deferred until your later death, and then your beneficiaries get it, and ideally they get it on a stretch out, so then the fund continues to grow income tax deferred through the beneficiary's death. So raising the RMD required date from 7.5 to 72 adds another year and a half when you don't have to start taking money out of the account. And so that was a good thing from the SECURE Act for most people, especially since a lot of people are working longer than they used to. There's another small exception in the SECURE Act that was a change, but it's only sort of a one-time thing, is if you inherited an IRA from 2015 to 2020, they changed the 5-year rule to the 6-year rule. And the 5-year rule typically applies when the beneficiary is not someone who qualifies for a stretch out. So it's not an individual, or it's typically if you name a charity or you name something that's not an individual that could qualify for a stretch out. So the 5-year rule is sort of the default rule. If you break all the rules, you name your estate as a beneficiary, you have no beneficiary, then the 5-year rule applies. And basically what they said is while we're transitioning here, we're going to give you an extra year. So if you have someone who didn't take all their distributions within the 5-year rule, they might fit into this rule, because again, if it was inherited in 2020, they'd have until 2025 to take the distribution, but now they get till 2026. So again, keep that in mind when you have someone who failed to take distributions, and they may fit into these rules. You may be able to avoid some penalties or some interest. Another change was that it used to be that once you started taking your required minimum distributions, in the old rule 70.5, under the new rule 72, once you started doing that, you couldn't make any more contributions to your IRA. So if you were still working at 75, even though you had earned income, you couldn't make contributions to your IRA. You couldn't keep funding your retirement. Now that rule's been changed, so there's no age limit. As long as you have earned income, you can continue making distributions to your IRA, even though you're also taking RMDs. In other words, you can keep putting money in there for your future retirement. They also changed the age limit on making charitable contributions. That is up to $100,000. Again, as long as you have earned income. So again, that's helpful if you're trying to get rid of your IRA and not have to pay income tax on it. And then there's one little final exception I want to point out, and that is if you take a distribution from an IRA before you're 59.5, there's a 10% penalty. It's an early withdrawal penalty. The idea is we're trying to keep you from taking the money out because we want you to leave it in there so that it's available for your retirement. That's the goal. But there's an exception for the first $5,000 you take out, even if you're under 59.5, if you use the money in connection with a birth or adoption. And this is a per person exemption. So a couple could withdraw as much as $10,000, obviously, from separate IRAs, but that could be helpful if someone is had a troubled birth, or they're trying to figure out how to pay for the expenses of an adoption. So we're just going to go through some of the big surprises in the proposed regulations. The first we've discussed it a little bit, is the age of majority. Everyone, I think, thought it was going to be 18 because that's sort of the rule for almost all the states. It turned out they decided to use 21. That's great. That gave us 3 more years of stretch, basically 3 more years before we had to start dealing with the 10-year rule. So basically turn the 10-year, from my perspective, the way I was looking at it last year, we now have a 13-year stretch because we were expecting to hit the 10-year rule at age 18, and now we're not hitting it until 21. So that was a good thing that came out of the proposed regulations, and it provided certainty, which is very helpful for planning. The other, I guess, surprise had to do with RMDs and the 10-year deferral. Most of us expected that if the 10-year rule applied, it didn't matter if the account owner had been taking required minimum distributions to the death. Once the new person took over and the 10-year rule applied, then we just started counting the 10 years. And you either took out a 10th every year, or you didn't do anything and took it all out in the 10th year, or you took some in some years and then waited around. But by the 10th year, you took it all out. And that was the only issue was make sure on the 10th year you've taken out the entire IRA. That was the only real plan. It was the only thing we were worried about. We wanted to avoid the excise tax for failing to take it out and make sure we took it all out by year 10. That was the rule. But as it turns out, the regulations severely complicate how you plan for IRAs, because you have to look first to, was the account owner taking required minimum distributions? If they were, then the rule is you have to continue taking those required minimum distributions over the 10 years. And then in the 10th year, take whatever's left. If the person wasn't taking required minimum distributions, then you could literally wait and take no distributions over years 1 through 9, and then just take the whole balance out in year 10. Well, that's two very different ways of approaching the IRA and how you're going to take distributions. And this regulation came out in February of 2022. Comments were due by June of 2022. And people are looking back going, but I've already taken I didn't take a IRA RMD in 2020 because I thought I had 10-year rule. I thought I could wait till the 10th year. And people in 2021 are saying, well, I didn't do it either. So this is a surprise. And it's there is some good news, but that was a surprise. Most people didn't realize that they were going to have to continue this paying on basically the same rate as was being paid at the time of the account owner's death during those 9 years. So again, I would pay particularly attention to that. It's very important to know, was the account owner in RMD status at the date of death? And if so, you've got to make sure you're taking those RMDs for the next 9 years. Another big surprise was very favorable treatment of see-through trusts. And I say favorable only because there just really hasn't been enough guidance to help people really know how these things work. You start looking at treatises on see-through trusts and you realize it's way more complicated than anyone thought it should be. But the good news was that the things we think of and how we deal with trusts when we set up trusts for beneficiaries that we don't think can handle the funds well, the familiar conduit trusts and the familiar accumulation trusts, these are both types of see-through trusts. Basically, the IRS sees through them and all those rules continue to apply. So all that stuff that you learned, you can keep in your head. But then they gave us even more benefits. They basically said, if you have violations of the identifiable beneficiary rule, and this has to do with how you calculate what distributions are going to be made, and that's related to who the beneficiary is and how old the beneficiary is. There's all these rules. And sometimes if you can't identify the beneficiary, then you have a problem. And your trust isn't a see-through, and now you got the 5-year rule, which the last thing you want is to fall back into the 5-year rule and have to pay all the income tax on the IRA in 5 years from the date of death. So basically what they said, I'll say some more later. Basically what the IRS said is look, you've got until September 30th of the year following the account owner's death to fix any problems in your conduit or accumulation trust. So, and they say fix, they're talking about identifiable beneficiary. So if you can't identify the beneficiaries, then go get a court order that says the scrivener made a mistake in what was intended, or the grantor's intent was that this trust be for the benefit of these people. Now they're identifiable. Now we know who the oldest person is. We can do the calculations. But it also gives us some other planning. So you remember I said earlier, if you have a mix of eligible and non-eligible beneficiaries, so you have people who qualify for an exception to the stretch out or to the 10-year rule, and the people who don't qualify, the rule is then the trust is 10-year rule. But if there was a way you could split your eligible and non-eligible, non-eligible beneficiaries into separate trusts, then you could have a 10-year rule for your non-eligible beneficiaries, and you could have a stretch out for your eligible. And again, you can do this by a non-judicial or judicial modification, as long as you get it done, by September 30th of the year following the account owner's death. And then sometimes there are powers of appointment that allow you to rearrange who the beneficiaries are. And again, by exercising those powers of appointment, you might, now qualify the trust as a conduit trust or accumulation trust, or you might be able to use that power in a way to reallocate who the beneficiaries are so that they then qualify for the exception to the 10-year rule. So that was very favorable. Weren't expecting that. Have hoped for that kind of guidance from the IRS generally. And we finally got a little bit of it here. Also want to say that the proposed regulations are effective for distributions that are made or required to be made after January 21, 2022 or later. And then there's a transition rule for the 2021 and 2022 and 2020. Actually, 2020, it comes under an exception under the CARES Act, we'll talk about in a minute. But it's very important to be able to fall into this transition rule, because if someone didn't make their RMD in 2021 or 2022, there's a 50% excise tax. And again, that's not helpful. And that tax is on the RMD that should have been taken. As I mentioned before, the comment period for the regulations ended over the summer. In October, the IRS actually put out a notice, and they talk more about the transition rules that they think they will have for people who died, for account owners who died in 2020 or 2021, where the beneficiaries might be subject to this 50% excise tax because they didn't take an RMD based on this new rule that says during years 1 through 9, because the account owner was taking RMDs, you have to continue taking those RMDs for the next 9 years. Well, obviously people can't go back and fix that. So they came out with this notice and basically said, when we come out with the final regulations, which we're expecting hopefully in December, but maybe not. But what these final regulations will say is that we're not going to force the final regulations on you until distributions for 2023. So again, they started out saying it's going to be effective for 2022. They're now saying when their final regs are only going to apply for 2023 and later. So that gives us a little breathing room. And then they also said we're not going to impose the excise tax for 2021 and 2022. And that if you already paid the excise tax, you can ask for a refund. So I think the IRS was being pretty generous there to help people get used to the new ideas that are coming down the road, because no one really expected this 9 years of continued distributions. That was a surprise for everybody. So let's go on now and just talk about, okay, I did my IRA planning, the SECURE Act came along, completely messed everything up. Now what do I do? And we'll just talk about some things you can do. And then why you might do it, and particularly when a trust has been named as beneficiary of an IRA, when you're trying to figure out what do I do now with it. But one thing that seems counterintuitive is we'll convert your traditional IRA to a Roth IRA. And the reason, although you're going to see this point one and go, well, why does it say that? The client pays the income tax now. Why is that good? Well, it's good for a couple of reasons. One, there's a lot of discussion about maybe income tax rates are going to go up. Higher than the 37%, the top rate we have now. So pay the tax now when the rates are lower. And so that you're getting an advantage there. Another part of it is that the clients, basically, it's like a gift to the beneficiaries, because the client's paying the income tax that the beneficiaries would have had to pay if it was a traditional IRA and was being paid to them. Because the Roth IRA distributions, there will be no income tax on. So that's a reason for considering that. And then down the road, just even though we did the Roth, and even though Roths don't have required minimum distributions, at year 10, a Roth still has to be distributed completely outright. But again, because it's not a traditional IRA, it's not as big a deal. And now here's an example of where you might want it in a trust, if you don't trust that the beneficiaries are able to just take the money and properly invest it. But again, you're getting discounted income tax for your beneficiaries, and paying those taxes now is reducing the client's estate. So there could be reasons why this could be good estate planning. And as I said, definitely still have to take it out of the 10th year. So it's not a be all end all. It doesn't give you a stretch, but it is a way to blunt the income tax impact of having to pay the tax at year 10. Another concept is to make your IRA payable to a charitable remainder trust for the benefit of the same beneficiaries that you would have named as the beneficiaries of your IRA. And so, basically what a charitable remainder trust does is you have a trust, you have a trustee, you make a gift of the asset to the trust. The trust is for the lifetime benefit of certain named beneficiaries, and then the remainder goes to charity. And then you have different percent payouts you're allowed to use, as long as, however you calculate it based on life expectancy of the beneficiaries, the charity actuarially ends up with at least 10% of the trust remainder. And again, it doesn't mean it has to be 10% because the people could end up living 20 years longer than they expected and the fund get completely used up. It might be more if the beneficiaries died earlier than expected. But you do the calculation when you set it up. And basically, you're now giving your beneficiaries a lifetime payout. They're not able to draw it out faster, so they're not able to waste it. And then, of course, you're giving to charity, and so your future descendants aren't getting any amount that might be left over. So let me just give you an example of this. Let's assume an IRA that has $750,000 in it. Let's assume that when we fund the CRT, we get a discount, a valuation discount of 33%. So basically, we're treated as making a contribution of $500,000 in terms of using up a GST exemption, a state tax exemption. This CRUT, it's a CRUT, so I'm setting up as a charitable remainder uni trust, which basically says every year give X% of the fund to the children. And then at the children's death, remainder to charity. Now, in this example, I didn't give you all the assumptions, but in this example, there's an immediate income tax deduction of $284,000. And then during the children's lifetime, they're getting estimated $1 million. And this is assets that are outside of the account owner's estate. And the account owner got the charitable income tax deduction of $285,000. Now, again, there is a 10% minimum benefit rule. So this doesn't usually work for younger beneficiaries. So like if your client's in the 70s, the kids are in their 50s, the grandkids are in their 30s, it might not work for grandkids, but it works real well for children. And basically what it's doing is the charity is basically paying out a benefit over the lifetime of the children, just like the old stretch out IRA did. And you're also getting some income tax deductions on the front end. The other thing you might consider doing is change the beneficiary to a see-through trust. So again, you're still going to have the 10-year rule. You're not getting around the 10-year rule with this planning, but instead of giving it outright to the kids, you can still use a see-through trust and still get at least 10 years of deferral where the kids can't just pull the money out. And hopefully by then they'll realize they need to leave it there and just let it grow or invest it properly when they get to the 10th year. So basically the way a conduit trust works, everything that's distributed from the IRA to the trustee of the trust is then paid to the primary beneficiary. So just think of like a pipe. You got the IRA on one end of the pipe, you got the beneficiary on the other end of the pipe, the trustee's holding the pipe, and any money that comes out of the IRA through the required minimum distribution rules or the 10-year rule is immediately paid on to the beneficiary. So there's no ability to accumulate any funds in the trust, but it keeps the beneficiaries from getting their hands on the trust and wasting it or using it too fast. It doesn't really matter who the remainder beneficiaries are until the primary beneficiary dies. It's fairly simple. It's fairly predictable. All the taxes are being paid by the primary beneficiary, not by the trust. And you can have a charity or a non-individual be a remainder beneficiary, which is, we'll see in a minute, accumulation trust doesn't work that way. And you can do some planning with the testamentary power of appointment to do some GST planning where you may force estate tax on beneficiaries instead of letting the GST tax apply. Again, there's some reasons why that might make sense. But again, you can't stretch it except unless this conduit trust is for eligible designated beneficiaries. So again, if you have eligible designated beneficiaries, a disabled person, a chronically ill person, or even if a spouse where you don't want the spouse to own the IRA outright, you can set up this trust and then it can be stretched for their life expectancy. So that's the advantage. Again, for non-eligible beneficiaries, for 10 years, they're protected from their improvidence. For eligible beneficiaries, it can be protected for their entire lifetime. Now, the accumulation trust, the benefit of the accumulation trust is that you can accumulate it rather than like the conduit where, again, like I said, the example of a pipe where the funds come in, the funds go out. So whatever the distribution is, that you're required to do that. Here, you can only have individuals as beneficiaries, including the remainder beneficiaries. You can't give testamentary powers of appointment, so there can't really be any planning or if you do, it can't be to a non-individual or charity or your estate. So there's some limitations there. But the beauty of it is the money just comes in and accumulates. The downside is that you pay income tax every year as it comes into the trust. So you don't have to pay it out, but you also have to pay the tax as it comes in. And just remember, trusts reach the 37% bracket for income tax purposes at just over $13,000 of income. So it's an expensive way to accumulate it, but it does keep the funds out of the hands of the beneficiary. If you fail to meet the requirements, then you're going to get stuck with a 5-year rule. So it's, you want to enter into an accumulation trust carefully. With both trusts, obviously they have to be valid under state law. They have to be irrevocable when the IRA owner dies, and the beneficiaries have to be identifiable. Now, that doesn't mean by name. It could be all my children or all my grandchildren. It could be a class of people so that you know who they are. And the test date for whether the trust is valid is September 30th of the year following the death. So again, we talked earlier about how there's certain things you can do to fix a trust, and you have until September 30th to do it. This is tied into that. As long as you can get everything lined up and correct by September 30th, then you're good. And then finally, you have to give a copy of that trust to the custodian by October 31st of the year following the account owner's death. And again, you'll see this date follows the proposed regulations, which also say if you have to prove disability or chronically ill, you have to do it by October 30th of the year following. So some of the advantages of a conduit trust, I kind of touched on them a little bit already. You keep the funds out of the control of the beneficiary for at least the 10-year period, and if they're an eligible beneficiary, for the lifetime. So again, that's why we do conduit trust. We're trying to give the beneficiary the benefit of the IRA without them being able to take it out early. Because again, with IRAs, if you own it outright, yes, there's required minimum distributions. Yes, it's spaced out over 10 years of your life expectancy, but there's nothing to stop you from taking it out faster and then incurring income tax. And then if you're not even 59 and a half, incurring 10% penalty, and then the money's not there later. And also, once the money's out, or once you own it, you could find yourself in a divorce or a lawsuit where creditors are trying to reach it. Now, the conduit trust does provide protection from creditors under Florida law, not under the bankruptcy rules. So it's sort of a halfway protection, at least for the 10-year period, if not for the lifetime, if the person's an eligible exception beneficiary. And again, by using trustees, you can kind of control how the money gets invested, and you create a third party who can decide, okay, this is helpful, not helpful. I'm not going to make the distribution, or I am, and this is why. Accumulation trusts, I have a lot more advantages here, but I don't know that necessarily either one's better than the other. But again, as before, you can accumulate funds, protection from creditors under Florida law, but not the bankruptcy laws. Again, protection from divorce. So those are all similar to the accumulation trust. You can structure it as a supplemental needs trust because, again, you can accumulate it. You're not required to distribute it out. Under a conduit trust, if someone's disabled and they're receiving government benefits, that forced distribution can literally disqualify someone from their benefits. So accumulation trust does have that advantage. And then if you're looking at the relative income tax rates and a beneficiary has a need and they're also in a lower income tax bracket, well, then make the distribution. And then they'll pay, maybe they're in the 20% bracket. So they'll pay 20%, whereas a trust would have paid 37%. So you just saved half of the money, half the taxes by going ahead and making a distribution. But again, you have that choice. This is an accumulation trust. You can decide if you're going to distribute it. And you can do it among multiple beneficiaries. So for example, you could say the beneficiaries are all 3 kids, but one child, is an executive in a tech company, and the other child has a job. It's an honorable job. It just doesn't make a lot of money. And so the trustees can say, well, based on what the grantor's guidance to me was, go ahead and make these distributions to these, to the child who needs it the most. You can do some GST planning. It's not very efficient, but it's better than a conduit where you can't do it at all, because the conduit just forces the money out every year, no matter what. And you can also have remainder beneficiaries who are older than the designated beneficiary. So sometimes that can be helpful, where you want to name like mom, and she's elderly. She may not have a long life expectancy, but on the other hand, you want her to be able to have some ability to get some funds, should she need them. So going on with some of the other things you can do for IRA planning, is, as we've sort of been hinting at, is modify if you have a trust already, then modify it either through non-judicial modification, a judicial modification, maybe a decanting the trust into a new trust with more better terms. And this is where you would, for example, as we said, you would say, let's split out the beneficiaries so that we have eligible beneficiaries in one, so we get a stretch out, and then the other non-eligible beneficiaries in another subtrust so they can be subject to the 10-year rule. But now at least not everybody is subject to the 10-year rule. Things you would put in the trust is you'd say, look, make sure you're distributing the smallest amount permitted by law, which under the old law would be the required minimum distribution. But under the new law, if you have an account owner who died while they were already taking RMDs, then they'd have to be taking those distributions over years 1 through 9 on the schedule, and then in year 10 the balance, and maybe even mandate. I mean, you have to decide what's best, but maybe even mandate, or at least strongly suggest, do 1/10 distributions so that you're spreading the income tax out over several years. Sometimes it's better to hold it till the 10th year, depending on your assumptions, because now all the money is growing income tax deferred until the 10th year. And sometimes that gives you a better final number. And then these changes also remind trustees, hey, remember, there's this rule, and if you're not taking it out fast enough, you're going to get a 50% penalty, or the IRS is going to disqualify the IRA. You don't want the worst case scenario, so remember to do that. And then, as I said before, you're going to add this flexibility to say, look, let's have the power to split the trust up if beneficiaries become qualified or non-qualified, in terms of an exception to the 10-year rule. And then a final thing to do for IRA planning is to say, okay, here's the impact. It's going to result in $500,000 less assets for the benefit of my children over their life expectancy. I'm going to go take out a life insurance policy for $500,000. Or if the number calculates to $1 million, I'm going to take a life insurance policy for $1 million, and basically just make up the income tax hit to your children by giving them additional funds through a trust that's outside your estate. Now, briefly, here as we get toward the end, I want to just touch on the 2020 CARES Act. The act had time limits because the CARES Act was a reaction to the pandemic, and so it really had a lot of dates and definitions that tied to 2019 and 2020. But you may have clients who come in and say, I didn't do this or I didn't do that. And as an example, they didn't take their RMDs in 2020. That's not a problem. They were waived in 2020 under the CARES Act. They come in and say, oh, and I didn't take them for 2019 either. That's okay. They were waived under the CARES Act, as long as you hadn't already taken them. You can't undo it. The law just basically said, look, if you failed to do it or whatever because you were so distracted by the pandemic, that's okay. But if you've already taken them, you can't undo it. It's done. You pay the income tax and move on. But if you didn't do it and you have a client who comes in and says, I didn't do it, then you know you're okay, because this law made that the case. And then there were also some special rules about taking coronavirus distributions if you took them prior to December 31, 2020. So again, if you have clients who come in and say, hey, I took money out of my IRA in 2020 and I wasn't supposed to, and I'm kind of concerned, I don't know what to do, and I need to report this income and I didn't report it, but you can go back and say, look, if you were affected by the coronavirus, diagnosed, or a spouse or dependent were diagnosed, you had a financial consequence as a result of being quarantined, or you couldn't work, your hours reduced, and you spent money on coronavirus expenses, and it happens to be hopefully more than what you took as a distribution that you shouldn't have taken. Well, first off, there's no 10% penalty, even if you're under 59.5 on the first 100,000. And although you have to pay income tax on it, you don't have to take it all out in the year you took it out. You get to report it in installments over 2020, 2021, and 2022. So the client comes in and says that, we might be able to report that, stretch the income out and avoid some penalties and interest, at least for 2021 or 2022, because you always have to look at what is the tax return filing date for your client. Well, for example, persons in the state of Florida, the filing date is February 15 of 2023. So people could still fit into these exceptions even for 2021 and certainly for 2022. And then the best part is if you got some money you can put it back in as long as you put it back in within 3 years of when you got the funds, and then no harm, no foul. It's sort of like the 60-day rule where you can take it out as long as you get it back in 60 days, no harm, no foul. Well, now you've got a 3-year rule. As long as you qualify, you have to go back up to A, as long as you qualify under A and B because of the coronavirus. And then again, just quickly wrapping up here, these same kind of rules apply for the 401k plans. And in addition to all the rules I just talked about for IRA distributions, they also changed the rule capping loans. So you could take out loans more than 50,000 or 50%. They increased that to 100,000 or 100%, as long as the loan was between March and September of 2020. But then a caveat, if plans they're now required to amend their plans to match what the CARES Act said, and any other ways they responded to COVID, and they have to make that amendment by December 31, 2025. So some time to do it, but there's some time to do it. So that wraps up this discussion on the 2019 SECURE Act, the proposed regulations under that act, and the CARES Act. I hope this was helpful to at least realize there are some ways you can bend and flex around the 2019 CARES Act and the 10-year rule, which is pretty draconian for traditional IRA planning, and that now it's giving you some ideas for how to address it going forward and maybe still get the benefit of the stretch out where you can.